I'm Alex Rushing, an attorney in Husch Blackwell's education group. Thank you for joining our program today. Before we begin, I would love to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all your questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We will use your feedback to plan future programs that are applicable to your institution's needs. This program was actually the result of multiple submissions discussing this topic in those surveys. So we really do focus on your answers to those surveys, so keep those coming. Joining me today are my amazing colleagues, Elizabeth Samples and Marissa Hodajak. Elizabeth serves educational institutions in various areas of compliance. She supports colleges, universities, and schools with day-to-day counsel, investigations, training, and policy system development. She draws on her experience as an attorney for the U.S. Department of Education Office for Civil Rights in supporting institutional non-discrimination efforts, including compliance with federal civil rights statutes and regulations, such as the Americans with Disabilities Act and Section 504. With an in-house background at a state university, Marissa assists the firm's education clients with a variety of legal matters. She works with institutions on policy review, provides counsel on compliance with education-related statutes and regulations, and guides clients through both internal and government investigations. As I said, I'm Alex Rushing, and I'm an attorney based out of our St. Louis office. I counsel higher education institutions across the country on investigations, litigation, and compliance matters arising from a wide range of harassment, discrimination, and safety issues. These include advising on matters in response to internal and OCR complaints, as well as litigation claims following alleged student or employee misconduct. That is it for the housekeeping items. Let's get started with our program today. So here's our agenda. As you'll see on the screen, we're going to start with a little bit of background on this topic related to body image and disordered eating in higher education. Then I'm going to turn it over to my amazing colleague, Marissa, who's going to talk about the relevant law in this space, the Americans with Disabilities Act, the Rehabilitation Act, Title IX, as well as some state and local laws. And then we'll turn it over to our awesome colleague, Elizabeth, who will talk about policies, some best practices, and some hypotheticals that hopefully we'll get a chance and some time to go through together today and walk through some scenarios that we've seen come up in our own practices. So with that, let's get started on the first section related to the background. Throughout this presentation, we will refer generally to both eating disorders and disordered eating as eating disorders, unless we specify that we're talking about one and not the other. An eating disorder is a clinical diagnosis as defined by the American Psychological Association's DSM-V, any range of psychological disorders characterized by abnormal or disturbed eating habits. Disordered eating is a descriptive phrase where people with disordered eating may not meet the diagnostic criteria for an eating disorder. The primary difference between the two involves the severity and the degree of symptoms present. And then body image, the final phrase on the screen, is a subjective view or mental view of one's own body. So let's go through some examples on the next screen. Here you'll see first some major categories of eating disorders: anorexia nervosa, which is an eating disorder characterized by weight loss where an individual generally restricts caloric intake. Bulimia nervosa is an eating disorder characterized by a cycle of binging and then purging, such as making oneself vomit. And then binge eating disorder, which is an eating disorder where an individual has recurrent episodes of eating large quantities of food and then feeling a loss of control because of it. The next box on your screen you'll see are various types of disordered eating. So how does this apply to all of you as higher education professionals? Well, eating disorders usually begin when individuals are between the ages of 18 and 21. Studies have shown that 11% to 17% of females and approximately 4% of males on college campuses in the U.S. demonstrate clinical eating disorder symptoms. Meanwhile, 20% to 67% of college students demonstrate some sub-threshold eating disorder symptoms. Historically, the majority of attention directed toward eating disorders at colleges and universities is focused on such behaviors in student athletes. As you likely know, this issue is prevalent all across various student populations. We will dive into the student athlete piece in the next couple slides as well. So the National Eating Disorder Association reported that the risk for disordered eating was not different among female collegiate athletes and female collegiate non-athletes. However, one additional thing to note is that athletes may be less likely to seek treatment for their disordered eating because of stigma, accessibility, or other barriers specific to their sport. So that's something to keep in mind. Notably, eating disorders have one of the highest mortality rates of any mental illness. For those of you who have experienced this issue on your campuses, you've probably considered all of the issues that are on your screen before. But for those of you who haven't, here's a list of the various concerns associated with this topic that we've seen come up in our own practice. Actually, we were just discussing that before we started the live webcast. Everything from danger to students' health and safety to OCR investigations and litigation. One of the biggest ways to mitigate against that risk is for you to have policies and systems in place. So I'm really looking forward to Elizabeth's portion of the training that dives into that much more in depth and discusses what you all can do from a practical standpoint in this space to try and mitigate that risk. So now we're going to talk from a poll question standpoint. Do you think the number of eating disorders on campuses have increased since the COVID-19 pandemic? Yes, no, or I don't know. So if you've had us minimized, bring us back up on your screen and answer this question for us. We'll give you a few seconds to respond. I see the results slowly coming in. We have about 10% of you who have responded so far. Wow, that shot up really quickly. We've got about 35% now. We have over 50%, which I love to see. And we'll wait a few more seconds and then close out the poll. I know under this new platform, you'll want to make sure that you can actually click it within the screen itself. It's not a separate window. I think in our old webcast system, it was a separate window. So if this is your first webinar in our new system, it may not be what you remember from the old one. Wow, what wonderful results. This is great. Okay, let's turn it to the next slide and see what you all said, and then we'll go over the answer. So it looks like over 75% of you said yes, that the number of eating disorders on campuses has increased since the COVID-19 pandemic. About 5% of you say no, it has not increased. And about 20% of you said, I don't know. I love the I don't know option. I had a client who told me, please don't just give 2 options or a few options. Give us the option to say we don't know if we truly don't know the answer to it, and then tell us what the answer is. So I always think about that client when we're developing these poll questions, and this is no different. So let's go over that answer and what the results are based on our experiences and what the Department of Education, the CDC, have told us. The number of eating disorders in young adults have increased significantly since the beginning of the COVID-19 pandemic. Researchers found that this was occurring across the country and not just isolated to any one geographic area in particular. Specifically, between spring 2020 and spring 2021, the number of eating disorder inpatient admissions almost doubled. There are a number of reasons for the increase, as you'll see on this slide, everything from disruptions in food availability to increased feelings of that loss of control that we talked about earlier. Another area that we've seen come up in our own practice and is supported by the data and studies on this topic is that gender diverse college students are at a higher risk of disordered eating. A study found that out of over 289,000 college students, the rates of eating disorders and disordered eating behaviors were much higher among students identifying as transgender. Over 15% of people who identify as transgender that were surveyed reported eating disorder diagnoses, compared with less than half of 1% in cisgender populations, according to that same survey. We think as higher education institutions, you all should be cognizant of this and take steps to proactively address these issues, such as through education on eating disorders and offering mental health resources. And again, we'll dive into some of those practical steps during Elizabeth's portion of the presentation. I do a lot of work in the student athletic space, so I'm very frequently seeing this issue come up related to athletics and student athletes. As you all know, student athletes often face extreme pressure to succeed and perform well and are typically at higher risk of developing eating disorders or disordered eating behaviors. Statistically, this is more common in female than male student athletes, but there's not a huge disparity. I think that's a perception, and that's not actually what the data tells us. Higher rates exist in athletic, endurance, and weight class sports like wrestling, rowing, cross country, gymnastics, swimming, and diving. But again, it's not only those types of sports. We're seeing it actually across all athletics. Approximately 84% of collegiate athletes reported negative eating and weight control behaviors. That was a really surprising statistic when I saw it, such as binge eating, strict dieting, fasting, self-induced vomiting, or use of weight loss supplements. So that's going to bring us to our next poll question. How many issues related to eating disorders has your institution handled in this past school year? 0, 1 to 5, 6 to 10, 10 plus, or I don't know. And we'll wait a few seconds for those results to come in. Great, I love when I see those numbers get higher and higher. Wonderful, we're almost at 50% response rate. We'll wait a few more seconds and make sure, I know a few of you are submitting them to the Q&A feature on the webcast. Make sure you're actually submitting it on your screen as opposed to in the Q&A. Otherwise we can't see your results in the larger survey. Okay, wonderful. We're close to well past the majority. So I'm going to close out the poll and see what the results are. We've got a lot of variety in terms of who's attending this webcast. So I'm very curious where you all sit on this issue. So we have about 2.5% of you have not had this issue at all come up. So that's really interesting. Almost 13% of you had this issue come up 1 to 5 times this past year. Almost 6% had it come up between 6 and 10 times. 15% about had it come up over 10 times. I'm surprised by that. That's really interesting to hear. I'm curious if those were sort of the same populations, right? Are we seeing that among one athletic team? Are we seeing that in one type of student population, or was it really across the campus? Very interesting. And then almost 64% of you said you weren't sure. So I'm glad we posed that as an option. That might be something when you go back to campus at the end of the summer or even now to sort of discuss at the end of this webinar. Have we seen this issue come up? This is something some of our colleagues across the country are seeing. Did we see it come up on our BIT team? Did we see it come up in athletics? Where did we see this come up, if at all, on our campuses? So that's it for my portion of the presentation. Now I'm going to turn it over to my amazing colleague, Marissa, who's going to talk about this area and the specific laws that apply. Marissa?
Thanks, Alex. All right, so let's talk about laws that are relevant to student eating disorder issues. So relevant laws include the ADA, both Title II and Title III, the Rehabilitation Act, Title IX, and various state statutes. Some brief background information about the ADA and the Rehabilitation Act. Title II of the ADA applies to public colleges and universities, while Title III applies to private entities that are places of public accommodation. So that includes private colleges and private universities. Then the Rehabilitation Act applies to institutions receiving federal assistance. So that includes most public and private higher education institutions. So is an eating disorder a disability? Not all eating disorders are going to rise to the level of a disability under the ADA. However, an eating disorder is a disability when the eating disorder substantially limits one or more major life activities. So this could include caring for oneself, eating, concentrating, sleeping. And some courts have actually addressed this question. Courts have found the following. Eating disorders must impact a major life activity, which we just talked about, which is a factual determination. Another court found that a school's failure to take disciplinary action on student harassment that was based on an eating disorder might be a form of intentional disability discrimination. And then another court found that failure to accommodate an eating disorder as a disability might also be a form of intentional discrimination. Under the ADA and the Rehabilitation Act, schools are not required to provide affirmative outreach programs to students who are navigating mental health-related disabilities, such as eating disorders. However, schools must provide reasonable accommodations to students who request accommodations and who can demonstrate that their eating disorder has risen to the level of a disability. And additionally, students who have an eating disorder, but it might not be a disability necessarily, but these people are still facing challenges relating to their eating disorder, they can still voluntarily seek out available campus resources, such as counseling. So how can schools accommodate students with eating disorders? As with most student accommodation requests, students should submit supporting documentation of their diagnosed disability. And then from there, the school should initiate the interactive process, which that includes an individualized analysis of the student's disability and accommodations that could be helpful to them. And this is usually done through a school's disability services office. The school will then work with the student to find reasonable accommodations. And while the school is not required to give a student their exact accommodation request, the school is required to engage in the interactive process to identify reasonable accommodations. So some potential accommodations for students with eating disorders could include dining hall or meal plan adjustments. So maybe extended hours for the student in the dining hall, or maybe a private area or private room in the dining hall for the student to eat. Also residence hall adjustments, such as a private room or a private bathroom or an emotional support animal. And then academic adjustments if a student's class performance is affected. So that can include extended time for testing if the student is having difficulties concentrating, extended time for assignments, flexible attendance if the student is experiencing symptoms like fatigue or something else where they're having trouble making it to class, or even maybe just permission to have snacks in class, or maybe allowing the student to have a break during class where they can go outside and have a snack. Continuing with our analysis of the ADA and how it relates to eating disorders, we'll talk about the direct threat test. So prior to 2011, the ADA permitted colleges to take actions such as involuntary leaves of absence for students who posed a direct threat to themselves or to others. But then in 2011, the DOJ amended Title II of the ADA to only state that institutions can address students who present a direct threat to others. So the threat of harm to students themselves was not mentioned. And after this, colleges were left grappling with what can they do if a student presents a threat to themselves, such as in situations where a student has an eating disorder, because a student with an eating disorder might not pose a threat to others, but their eating disorder could pose a threat to them personally due to the serious health impacts. So what steps could a school take to try to protect these students with eating disorders when an involuntary leave of absence is likely in the student's best interest? In 2018, during a NACUA briefing, an OCR official shared some best practices for colleges to protect students who were at risk of self-harm. And this official recommended that schools steer clear of using the direct threat terminology or that framework, but the official shared best practice recommendations for involuntary leaves of absence. So this included involuntary leaves of absence should be considered as a last resort. They must be determined on an individualized basis. So a school shouldn't have a policy that says if XYZ is met, then a student is automatically involuntarily withdrawn. It needs to be on a case-by-case, individualized basis. Colleges should also consider how a student's behavior impacted the campus community, and students should have a mechanism to challenge a leave decision. So if a student is told that they're being involuntarily withdrawn, how can they appeal that decision? How can they challenge it? Another law that is relevant to student eating disorder issues is Title IX. Title IX prohibits discrimination on the basis of sex in education programs and activities that receive federal funding. And there have been some student plaintiffs who have alleged that schools discriminated against the student in violation of Title IX because eating disorders primarily impact women. That's what the plaintiffs were saying. So one such case was Franchi versus New Hampton School, where a parent of a secondary school student sued her daughter's former school for violating Title IX after her child, who suffered from an eating disorder, was discharged from the school. So Franchi alleged that the school discriminated against her daughter on the basis of sex because eating disorders disproportionately impact adolescent females. However, in this case, the court found that Franchi did not plead that the school regularly discharges students with eating disorders, which results in the dismissal of more girls than boys. Some states also have statutes that are relevant to student eating disorder issues. And state statutes relating to eating disorders, disordered eating, or body image are not present in every state, but where they exist, trends include focusing on creating mental health education programs generally, and some statutes do refer to eating disorders specifically. And so some states with statutes like this are Missouri, Illinois, Florida. However, the larger focus is on creating mental health education programs within K-12 school districts as compared to higher education institutions. And while there have not been many student eating disorder cases that have been brought under state law, there have been some. One case involved a state tort law claim, which found that a claimant's eating disorder-related injury needed to be permanent and substantial. And recently, parents of a Jacksonville University student filed suit against the university after their daughter, who was a Division I cross-country athlete, died by suicide. The parents claimed that the university allowed the cross-country coach to fat shame and bully the women on the team, including their daughter. The parents also alleged that the university did not provide their daughter with her needed accommodations. The parents brought claims under the Florida Wrongful Death Statute, the Survival Action Statute, breach of contract law, as well as the ADA, Section 504, and Title IX. Another legal issue that schools should be aware of is the risk of an OCR investigation involving students with eating disorders. Eating disorders are comparable to other self-harm behaviors, and OCR has issued several resolution agreements related to self-harm behaviors, which is also discussed in a great NACUA note by Hannah Ross and Jean Kincaid. So some schools that have had these resolution agreements are University of Rochester, where OCR found that the university had legitimate non-discriminatory reasons for recommending a student who was reported by a friend to be planning to die by suicide to take a voluntary medical leave of absence. And they found that the university adequately made an individualized determination in accordance with its policy and also adequately sought input from the student's healthcare providers. Rutgers University also had a resolution agreement. And the DOJ has also entered settlements with schools regarding self-harm behaviors. Some schools include Quinnipiac University, the University of Tennessee Health Sciences Center, Princeton University, and Northern Michigan University. And with University of Tennessee Health Sciences Center, the settlement said that schools can impose legitimate safety requirements necessary for the safe operation of their services, programs, and activities. Thus, a student may not be qualified to be enrolled at a school if the student cannot fulfill the school's safety requirements. And while it does not appear that OCR has entered a settlement with the school regarding eating disorders specifically, it does still remain a possibility that schools should be aware of. And finally, schools should be aware of the risk of negative publicity involving student eating disorder issues. As you can see from these headlines, colleges and universities are regularly criticized in the media for their handling of student eating disorders, as well as the perpetuation of eating disorders on college campuses. University-run publications often run articles authored by students that are especially critical of how university resources fall short of helping students with eating disorders. And the majority of media coverage also focuses on how social media and the COVID-19 pandemic are driving forces behind the rise in eating disorders. And with that, Elizabeth is now going to talk about policies.
Thank you, Marissa. So let's start this section on institutional policy with our next poll question. Does your institution have any policies relating to eating disorders? Yes, no, or I don't know. And I'll give you a few moments to submit responses. Like with many of the substantive areas we cover, frequent recommendations are to take inventory of policies and procedures that you have internally that might relate to them. So we thought it was important to pose a question to you all to see whether you have policies specifically relating to eating disorders. see about 65% participation. So I'll go ahead and move to the next one. So about 20% of you say that your institution does have policies relating to eating disorders. About half of you say no. And another 35% say that you don't know. So again, this is a good opportunity to perhaps consult with colleagues and make some assessments of whether you have applicable policies and procedures. So first, before launching into discussion of relevant policies, want to perhaps, acknowledge that this is certainly a really difficult and complex aspect of student support that you and your colleagues are potentially grappling with. There's an intersection of many issues, as Marissa and Alex have already highlighted. There are, of course, legal principles that may apply as it relates to accommodating and supporting students with disabilities under the law, but short of that, even if something doesn't rise to the level of a disability, as those of you who know who are dealing with this and other student support issues, there are many factors and considerations that you're having to deal with on the ground, when dealing with these really important student support issues. So one of the ways that you can help put framework and lead to potentially better outcomes for community members is to have an understanding of policies that may directly apply to eating disorders or that may apply sort of indirectly, right, even if they aren't addressing eating disorders specifically. So in our experience, few institutions have policies that relate to eating disorders specifically. More commonly, though, institutions will have policies that relate to mental health or other disability-related issues or other care and concern issues that do have application to issues related to eating disorders. So these may include leave policies, right? As Marissa identified from guidance, through the Department of Education, voluntary leaves of absence are always preferred, right, over involuntary leaves of absence. That may or may not be something that is ultimately determined, is available. That is a voluntary leave of absence. But your institution's leave of absence policies may be applicable, right, in situations where a student is facing potentially more, serious impacts related to an eating disorder or disordered eating and needs to take a leave of absence from their studies. If, again, a voluntary leave of absence is not an option, the institution may be moving through its involuntary withdrawal policies to make determinations about student participation. Other frameworks that may be in place, although not directly targeted at eating disorders, but will be applicable, will be your internal processes related to behavior intervention teams or care and concern teams. As Marissa highlighted, we have guidance from the department, from case law, about what these teams need to be considering when making determinations. And so this is an opportunity to evaluate perhaps your behavior intervention team policy and procedure. Number one, to make sure it's legally compliant, and number two, to consider whether it would appropriately cover issues of potential eating disorders, and if not, whether things may need to be adjusted. These policies typically include clear guidance about who will be involved in this team approach, particularly in the area of student service. We can see turnover in some offices that present challenges, for institutions to be able to, kind of continue this work. So it's important to be kind of periodically evaluating who is available internally to serve on these behavior intervention teams, these care and concern teams, and make sure they have the attendant sort of training related to that. Also, because of issues of turnover and because of the fact-specific nature of these analysis, documentation becomes critically important, right? So when you're looking at your behavior intervention teams, your applicable policies and procedures, it's always advisable to evaluate what are your documentation policies and procedures related to these issues to ensure that there is good documentation of what is often a sort of progressive kind of evaluation and analysis. So that if we have staff turnover, if we have issues of escalating situations, there is internal documentation and resource available for someone to go in and understand, what has occurred. And then, beyond general policies, it's also important that institutions consider what resource guides do we have available for our community members regarding access to campus mental health resources, and are those resource guides written in such a way, published in such a way that they would cover, providing information for students who may have questions about resources related to eating disorders or disordered eating. So developing these kinds of policies, taking this kind of inventory helps institutions to be better prepared if there are issues that come up related to students and eating disorders. So when you think about sort of evaluating these policies, there are some questions that you can ask to sort of evaluate whether they adequately cover issues related to eating disorders. So do our policies, do our trainings tell faculty and staff what they should do if they suspect that a student has an eating disorder? Do we have trainings that are being offered to our community members about eating disorders or disordered eating? How often are those trainings conducted, and who receives those trainings? What is the content of the trainings, and are they mandatory? So just like other areas of compliance, right, and areas of student support, when you're thinking about the effectiveness of your training, these are the types of questions that you could pose internally and to administrators and colleagues about whether there are trainings related to faculty and staff and students on this important issue. When it comes to involuntary withdrawal, do we have clear policies about when that can be used? And if so, what the process is for determining whether an involuntary withdrawal will be an option. And again, I talked with some of that on the last slide. When we move to an involuntary withdrawal option, what does our policy say about who needs to be involved in that determination, and what types of procedural requirements are there for involvement by the student, potential appeal by the student? What processes and directives are in place for ensuring that this is a fact-specific determination, that it is one that is informed by student participation if they choose to participate, one that is informed by influence and scientific and other sort of medical documentation from providers, so that we can ensure that we're not making these determinations based on stereotypes, but on truly fact-specific inquiry about a specific student situation when we're moving to the more extreme option of involuntary withdrawal. And then finally, again, considering in a time of, we understand kind of limited resources often available at institutions, what resources does the institution have presently for students with eating disorders? And if there are limitations internally with respect to, supporting eating disorders, what kind of community resources do we have available that we can refer students to and make sure that they're educated about options related to other types of supports? There are some specific athletics policy considerations. Alex mentioned, in our practice, we frequently advise athletics departments on various issues, including potentially issues related to eating disorders or disordered eating. And so sometimes athletics departments consider having separate eating disorder policies for student athletes, or at a minimum, focus on guidance and resources that are available to student athletes as it relates to mental health support or guidance on proper nutrition to the extent that that might be useful. Training for athletics department staff and coaches can also be very beneficial. Coaches can be required to undergo trainings on identifying eating disorder behaviors, and again, what to do if there are suspected student athlete eating disorders. This type of training can be very useful and provide, support again to coaching staff and other athletic staff in again what can be a very complicated area to navigate. It can be an area that is misunderstood by some individuals without the relevant sort of expertise, and although sometimes individuals can be very well-meaning, right, without appropriate kind of guidance and training, there can lead to sort of difficult situations within athletics related to this. So, in addition to having potentially specific policies, identifying resources, providing training, there should also be an investigation and grievance process for student athlete complaints. This may be a general complaint process through which student athletes may be able to individually or collectively identify complaints related to comments or practices related to body image, potential disordered eating. This might be issues related to weight checks or comments regarding weight, the way that weight and BMI information is shared and disclosed among student athletes. All of these things can have an effect on individuals who have disordered eating or have eating disorders. And so through student athlete complaints, the institution may receive kind of concerns related to some of these behaviors and practices, and then should engage in investigation, fact finding to determine if anything needs to be done to address them. And with that, I'd like to move to a few scenarios, and we'll share a hypothetical situation, and then walk through some potential questions related to how the institution may respond. So here, scenario one, I'll read it out loud, and you can also read it on your screen. Student A is in university's physician's assistant program and has clinical rotations in the NICU at university's medical center. Student A is ranked first in his class and consistently receives positive feedback from medical center faculty. However, over the last year, faculty and students have noticed student A has lost significant weight. Student A tells others that he has been working out and eating healthy, but he has an undiagnosed eating disorder. Student B confides in Professor C that she is worried about student A not eating because he always makes up an excuse not to eat and is showing trademark symptoms of anorexia. Some of the symptoms include fatigue, being cold, thinning hair, excessive weight loss. Professor C meets with student A to ask if he needs help, but student A says that he is fine. So we have here, despite potential trainings we have available, information we have about resources, student A himself has not come forward and identified any concerns on his own behalf. He has not, taken the step of requesting any accommodations and is not seeking those other kinds of resources. But we have a report of concern from a fellow student that professor has received and is now trying to determine what steps may need to be taken. So there's a few options, right, that track kind of some of the potential applicable policies that I talked about a few slides back. So an option would be referring to the campus's behavior intervention team, or whatever the sort of equivalent would be at your institution. Another option would be to provide the student with campus mental health resource options, or perhaps more specifically, resources that are available related to eating disorders or disordered eating. Another option may be to provide the student with the disability coordinator contact information. As Marissa reiterated, during her section, the onus is on students in the higher education context to identify themselves as a student with a potential disability and take the step to request accommodations. And that process gets initiated with contact, to the Disability Services Office. And so an option here may be for Professor C to provide that information to the student. And then another option may be to continue to monitor the student and see if academic performance drops, if weight continues to drop, or if other concerning behaviors are noted. And so in thinking through this scenario, the three of us, kind of talked through these various options, right, that are available to the institution. And given the facts that we know, and we don't obviously know them all, there may be additional information that needs to be collected, but because we aren't yet seeing a decline in student A's performance, we're not seeing a potential, increase in absences or decreased academic performance, inability to, participate in the program. And because we don't have student A seeking advice or accommodations or resources, this strikes us as a point in time at which the more sort of escalated kind of response, like convening a behavior intervention team, or even referring the student to disability services coordinator, is not warranted at this time. We did talk about, though, because often situations that behavior intervention teams need to deal with, because they often do escalate, and sometimes it can be important to at least document a starting point, right? So depending on what your internal kind of processes are, what sort of options you have for documentation, this may be at a minimum an opportunity to document that there was a reported concern related to student A, that it came from a student, and that Professor C followed up with the student and sort of identify, what student A's response was, and make some sort of notation about potentially continuing to monitor, the student's performance and reevaluate if there are any future concerns that arise. When it comes to, convening a team, we talked earlier about some of those components. They really involve they can involve coordination with the student, and the student providing information, documentation about their experience, perhaps medical care provider documentation. And we really here don't yet have indications, right, of potential inability to participate from the student, but we may get to that point. And one note about sort of referring to the disability coordinator, one of the concerns there would be that, when we think about our students with a disability, there are various ways that an individual can be found to have a disability under the law. Not all of those require accommodations. A student must actually have a substantial limitation of a major life activity to be entitled to accommodations. But an individual may also be regarded as having a disability, which can then initiate protections related to different treatment, a lack of access to programs, disability harassment. And so it's important that we kind of consider, not inadvertently regarding someone as having a disability who may not, in fact, have an eating disorder under the law that qualifies as a disability. So those are all some things to kind of consider as it relates to scenario 1. Now we'll move to scenario 2, which is essentially one of the things that potentially I forecasted in talking about scenario 1, an unfortunate escalation in the issues that the student is facing. So now we have the same facts as before, but after meeting with Professor C, student A, continues to not seek help, and his eating disorder remains untreated. So after a month goes by, student B again reports, this time not only right in the sort of posture of a fellow concerned student, but now student B has specific information about sort of performance issues. So here, student B reports that a distraught parent told medical center staff that student A almost dropped her child while he was lifting the child from the crib. After conducting a preliminary investigation into the matter, other students also confirmed to university personnel that they have noticed student A's hands and arms shaking during his shifts. Student B also tells investigators that she has witnessed student A struggling to lift hospital equipment on multiple occasions, and that she often sees student A sleeping during his shift. So now we have, again, an increased level of concern, and it's not only now a level of concern, right? We have specific information about performance-based activities that this student is carrying out in his program. And so this changes, right, the obligation to take sort of more significant action. Now we have, while we also have potentially more information about the student's threat to himself as it relates to his eating disorder, we also now have potential information about harm to others that he is engaging with through his program. And so depending on to what level this was referred to the BIT team previously, now we absolutely need to make sure that we have behavior team intervention involvement, and that they are engaging kind of consistent with the policy and procedure in the right steps to gather information about what's occurring here related to this student and how it is impacting their participation in the program. And we have now some specific reports that are fact-based about the potential issue with the child. We have observations of the student's hands and arms shaking. And so we've moved from the sort of scenario where we have sort of concerns about potential impact to actual documented impact, on the student and others that he is serving. And so this also then raises issues where, the institution, the BIT team, would consider, contacting, in-house or external counsel to seek guidance related to what steps need to be taken in the interim. Are we in a situation where potential interim removal from rotations is warranted, because of some of the things that we've learned about the students' engagement and potential lack of ability to carry out the program participation safely. And then we're using that information to make determinations about the student's level of participation. And so again, here it's really important to consider what is the student's current participation and what changes might potentially need to be made on a voluntary or involuntary basis. So first, the team might be considering, okay, now that these situations have arisen, what is the student's response, right? In the previous scenario, the student was reluctant to identify any concerns, that he had. He wasn't seeking any resources. Perhaps that's changed over the last month. And so what is the student saying now about his condition, about how that's impacting him, and what options might be available, right? So maybe now we are talking about a potential voluntary leave of absence. If not, then again, maybe we're talking about some potential sort of pauses to some participation. Do we need to put limitations on the actual sort of clinical component to this, the actual patient-facing component? Are there other things that the student can continue to engage in safely and that will kind of align with, proceeding with the program objectives? Or do we need a full-scale involuntary voluntary leave of absence? So again, I think there would be more fact collection that the BIT team, would be engaging in. This sort of scenario references a potential investigation that's been conducted. So using some of that information, right, to inform its decision, and making sure that there is involvement with the program to understand, if we're going to put limitations on the student's participation, what are those? And giving that student the option to, participate in that behavior intervention team process and provide information. And again, this in the course of a month here, we saw significant change as it related to the student. And the unfortunate reality is that may continue, right? And so it needs to be a process where the behavior intervention team is able to kind of continue to take information in and make these determinations, again, with consultation, with counsel when there are sort of escalating concerns, not just related to taking more significant measures related to student participation, like involuntary withdrawal, but certainly also if there are escalating concerns related to the student's well-being. And whether decisions need to be made related to that. And so now we'll move to a final scenario. Here, the college's gymnastics team members are being interviewed by the college's Title IX investigator after reports were made that an assistant coach made inappropriate sexual comments to some of the gymnastics team members. During an interview with student athlete 1, investigator asks student athlete 1 what the student's experience has been like with the assistant coach. Student athlete 1 says that the student has not had a great relationship with the assistant coach, and upon further questioning, student athlete 1 reveals that the student has been struggling with binging and purging for a few months after the assistant coach told student athlete that the student would perform better if the student weighed less. So here we have a sort of unrelated, right, investigation that involves student athletes, where now we have a student athlete who has shared information about potential disordered eating, perhaps even rising to the level of an eating disorder under the DSM for a few months after the assistant coach had made comments about the student needing to weigh less. So here we have, potentially, two issues. We have the student athlete on her own part, raising concerns about treatment that she experienced, and potentially we have a broader issue that may relate to this assistant coach. If this is more kind of widespread, that is, these kinds of communications or treatments of student athletes. So the options would be, for the Title IX investigator to share this information with the Title IX coordinator, right, as being collected, related to the investigation, in order to make determinations about, referral to a behavior intervention team, potentially for the student athlete, or to the equity office on campus, so that an investigation can be conducted related to this student athlete's experience. And then again, potentially, as it may extend, beyond this one student athlete. For this individual student athlete, it would be important to provide, resources and options about, campus mental health providers, health clinic resources, et cetera, and then providing potential interim supportive measures that may be necessary for the student athlete. So again, I think this is a situation where the institution would be considering, what institutional policies and procedures would be best aligned to gather more information about the student athlete's experience, and conducting an investigation to determine, whether there has been potential misconduct under athletics department rules or other institutional policies, related to this treatment by the assistant coach, and then taking action if needed. Sometimes this type of report can prompt, a broader sort of review related to student athletes, either on this team or more broadly, throughout the department. So that might be something that the institution is considering, but we don't necessarily know how widespread this might be, from this individual sort of complaint that's been received. And so the institution would be wise to sort of carefully kind of consider, right, the scope of a potential review, and perhaps provide sort of more targeted investigation and response, maybe as it relates to this team. And beyond sort of a fact-specific kind of investigation, institutions can always, and departments can always make determinations about training, right, that may be provided. And so perhaps this is, depending on what the investigation reveals, perhaps at a minimum, this is a situation where the institution is considering targeted training, right? Because that's not necessarily, targeted to a specific individual or targeted to a specific coach, but may reveal an opportunity to provide, some additional training for members of athletics. So just to kind of summarize some best practices related to policies and procedures and to some of the scenarios that we've talked about. This is an area that has clear potential overlap with disability accommodations if an eating disorder is considered a disability under the law, depending on the individual's condition and the impact that it has. So certainly institutions need to engage in the interactive process when accommodations are requested. Again, this is an area to kind of evaluate what training is provided, and what options do we have for providing some additional training to support our community members, support our faculty and staff and administrators as they're trying to provide student support in this way, and to provide our students so that they understand the resources available. And then again, with respect to policies, there can be standalone policies, or there can be definitely the applicable policies that we talked about that you already have in place. This can be an opportunity to revisit those and make sure that they are aligned again with legal obligations, and that they're working practically, for your institution, that we know who is actually serving on these teams and that they have the training that they may need. If there are concerns about specific student populations, the institution may consider conducting assessments. But again, like other kinds of climate assessments, broader assessments, institutions need to be sure that if they are taking that step, that they also have the resources and readiness to sort of back up those findings, so that if it is taking that step to make, gather information about these potential issues, that it's then prepared to address them. And then again, creating appropriate response teams. A final note about FERPA. Of course, all of this type of situation that we're talking about will undoubtedly involve student educational records. And so institutional officials need to be cognizant of their FERPA obligations not to disclose information either orally or through actual transfer of records, related to those students, unless an exception applies, which it may, to the extent that there are, health and safety concerns related to these students. So with that, we have reached the end of our time. I see that we might have had a few questions, but I think at this point we will just address those as we're able after the presentation. Thank you very much for participating today. We hope the information was useful to you and your organization. As a reminder, the program has been approved for legal education hours. To report your hours, you can click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with the recording of the webcast for you to watch and share. And then please, again, be sure to complete our short survey. Like Alex said at the beginning, we do use that information to help plan future webinars to help support you and your colleagues and institutions. So thank you again. Have a good afternoon. This concludes our webinar.